Hello, good evening, everyone.
Good evening, sir.
Good evening, sir.
So, alam nyo, alam nyo ba yung schedule ng exam natin? Di pa kasi ako nag-update. If kailan, kung anong oras ng exam. Aware ba kayo?
Sir, Friday po.
Friday? Anong oras?
6 to 7:30.
Thank you. Okay. So, mag-skip muna tayo sa hindi na muna tayo mag excuse me, mag-prayer. Kasi habulin natin tong limited partnership. Take note, tomorrow may quiz kayo Although hindi covered itong limited partnership.
Okay, sir.
Hindi covered ng quiz nyo pero sa exam covered siya. So, let's start with limited partnership. So, this is a special kind of partnership. Iba siya dun sa general partnership as we have glanced dun sa general provisions of partnership. So when we say limited partnership, this is a partnership formed by two or more persons under the provisions of the following article, meaning Article 1844, having as members one or more general partners and one or more limited partners. So, if to translate me into simplest terms, at least one general partner, at least one limited partner. The limited partners, as such, shall not be bound by the obligations of the partnership. Therefore, the limited partners have limited liability. Kumbaga parang investors lang sila. Okay? So, kailangan pa rin merong general partners or general partner para habulin ng partnership creditors just in case that the partnership assets are not enough to meet the partnership liabilities. So, ang sabi dun kanina, dun sa definition, two or more persons under the provisions of the following article. So, from 1843, ang following article mo dyan is 1844. Okay? So, we have there the requirements for formation of a limited partnership. The first one, sign and swear to a certificate. Na-discuss ko na rin ito noon sa Chapter 1, yung general provisions. And then you have to file for record that certificate in the SEC. Okay? Why? Why do you need to sign and swear? And then you file it for record in the SEC to give actual or constructive notice to potential creditors or persons dealing with the partnership that the partnership has a nature of limited liability. Yung limited partners has limited liability. Para hindi sila later on mag-question if isa lang yung general partner, isa lang ang mahahabol nila. So yun, para meron ng notice sa kanila sa potential creditors, partnership creditors, na aware na sila the fact na yung partnership na ito is may limited liability. Yun yung reason bakit kailangan mag-sign and swear the certificate and then must be submitted to the SEC. Okay? After a limited partnership has been formed, additional limited partners may be admitted, provided there is proper amendment to the certificate, which must be signed and sworn to by all of the partners, including the new limited partners, and filed in the SEC pursuant to the requirements of Article 1865. So, hindi siya gaya ng general partnership na you just need the consent of the partners kapag merong gustong ma-admit as new partner sa isang partnership. Dito sa limited partnership, kailangan yung certificate na sinasabi natin kanina kapag may dadagdag na bagong limited partner. Okay? Dapat ma-amend yung certificate na yun. Okay? And may pass on record again to the SEC. So yun yung difference niya sa general partnership with regards to additional partners. Okay? So, tandaan, pag limited partnership, at least one general, at least one limited. Sabi natin kanina, sign and swear to a certificate. Ano yung isa-sign and swear mo? First, yung the name of the partnership. Okay? Dapat dun sa name ng partnership, meron yung word na limited. Bakit? Same as I have discussed kanina, to put the persons you are transacting with actual or constructive notice na yung partnership na yan has limited liability. Okay? 2, the character of the business, the location of the principal place of business, of course, the name and place of residence of each member, general and limited, the term for which the partnership is to exist. Take note, nung na-discuss natin before, kapag general partnership yan, na may term, kapag nag-expire yan at tinuloy, okay lang. Tuloy-tuloy siya. Pero kapag limited partnership siya at nag-expire, tapos tinuloy, na hindi inamend yung certificate, okay, na pinasa sa SEC, magiging general partnership siya. So you take note of that. So, if you want to keep the nature of the limited partnership, dapat i-amend mo din yung certificate na pinasa mo before sa SEC. So, yun. The amount of cash, of course, and the description of, and the agreed value of the other property contributed by each limited partner. The additional contributions, if any, to be made by each limited partner and the times at which or events on the happening of which shall be made, of course, if when these contributions or additional contributions shall be made. The time, if agreed upon, when the contribution of each limited partner is to be returned. Okay? Take note, guys, yung H, the time, if agreed upon, when the contribution of each limited partner is to be returned. So, unlike sa general partnership, na hindi mo basta-basta makuha yung share mo dun sa partnership without dissolving the partnership. Ito kasi, pwedeng after 1 year, if naka-indicate sa certificate, may babalik yung capital ng limited partner, pwede yun. Pero may condition dun. I-discuss natin later on. The share of the profits or the other compensation by way of income which each limited partner shall receive by reason of his contribution. And then, magsasign and swear ka rin to these rights. But, take note, this does not exist as a matter of right. This must exist in the certificate in order for it to be called a right. Okay? So, unlike yung right to inspect, right to access, right to copy, right to full disclosure of information, na meron talaga yun, existing yun sa batas. Ito, hindi sila existing. Existing lang siya pag meron sa certificate. Okay? The right, if given, of a limited partner to substitute an assignee as contributor in his place in the terms and conditions of the substitution. The right of the partners to admit additional partners. So, hindi pala basta-basta mag-admit ng additional partners, kailangan given din siya sa certificate. Okay? The right of one or more of the limited partners to priority over other limited partners. Ito yung preference over other limited partners. Okay? Pwedeng sa 5 limited partner, mauna muna si A bago si B. Okay? Basta sa kanilang limited partners lang. Okay? Kasi tandaan nyo, itong limited partners, may preference sila over general partners. The right, if given, of the remaining general partner or partners to continue the business on death, retirement, civil interdiction, or those grounds that will dissolve the partnership. Take note, if given. So, hindi yan nag-exist unless stated in the certificate. So, yan yung dapat nyong tignan. The right, if given, of a limited partner to demand and receive property other than cash in return for his contribution. Kasi nga, ang limited partner, guys, must only receive their shares in cash generally. So, pag meron sa certificate na pwede silang mag-receive ng property in lieu of cash, why not? Pwede. Okay? Characteristics of a limited partnership. It is formed by compliance with the statutory requirements, yung sinabi natin kanina, 1844. Okay, ano yun? Sign and swear to a certificate. It must be filed with the SEC. Okay? Second, one or more general partners control the business and are personally liable to the creditors. Of course, you know that na. One or more limited partners contribute to the capital and share in the profits, but do not participate in the management of the business and are not personally liable for partnership obligations beyond the amount of their capital contributions. Meaning, they are, in essence, only investors. Diba? Minsan, hindi mo alam yung pangalan ng investors kasi hindi sila active sa management. Okay? They are only interested with the share, okay, that they can get from the partnership. The limited partners may ask for the return of their capital contributions under the conditions prescribed by law. So, i-discuss natin yan later on. Ayokong i-discuss ngayon kasi merong specific article regarding that. The partnership debts are paid out of common fund and the individual properties of the general partners. Take note, limited partners are not liable to the extent of their separate property. They are only liable to the extent of their capital contributions. Business reason and purpose of statutes authorizing limited partnership. Bakit nga ba ino-authorize ang limited partnership? Okay? Bakit ina-allow na pwedeng isang tao lang mahabol yung general partner lang? Why? These reasons. Secure capital from others for one's business and still retain control. Ideally kasi, ang limited partner is basically para siyang sole proprietor, pero you need the capital or the influx of funds from other people. Kunwari, ikaw is chef ka, galing ka magluto. Hindi enough ang capital mo. The scenario is, you will get investors, or in this case, limited partners that will contribute capital for your business. Okay, ganun yung idea niya. Which is, ikaw na general partner, you can either contribute industry, capital, or property, and at the same time, ikaw na magmamanage ng business. Kasi take note, ang limited partner, they cannot manage the business. Once na nag-manage sila yan, they are liable as general partner. Okay? Therefore, liable sila hanggang separate property nila. Okay? Share in profits of a business without risk of personal liability. Precisely on the part of limited partners, di ba? You share in the profits, but you do not risk your separate properties. You only risk the capital you contributed. Associate as partners with those having business skills. As I have explained kanina, ganun yung scenario kasi ng limited partnership. Okay? Merong isang tao na may skill, na may business, pero hindi niya kaya yung capital na siya lang. Okay, what he will do is, he will associate with people as investors. So dun pumapasok yung limited partners kasi hands-off sila sa business. Si limited partner lahat ang magmamanage, si general partner lahat ang magmamanage sa lahat kasi liable din siya up to the extent of his personal properties. Okay? Distinction between a general partner or partnership and a limited partner or partnership. So number 1, general partner is personally liable for partnership obligations, of course. Hanggang sa separate properties niya, sasagot siya. Pero si limited partner, only to his capital contributions. So if he only contributed 40,000, he is only liable up to the extent of 40,000. Okay? Number 2, have equal right in the management of the partnership. Just in case na 2 or more ang general partners, they have equal right in the management of the partnership. But the limited partner, as I've said earlier, cannot manage the partnership. Okay? Third, the general partner may contribute money, property, or industry, while a limited partner, take note, may only contribute money or property. In short, capital lang. Capital lang talaga, money or property. The general partner is the proper party to proceedings, meaning siya yung sinasama mo pag kinakasuhan ng partnership. Let's say for example, kakasuhan mo ang partnership, okay? After putting the name of partnership, lalagay mo yung pangalan ni general partner. Siya yun. Okay? Kasama siya dun sa kaso. Okay? But for limited partners, hindi sila kasali sa proceedings. Why? Because they only invested capital. Hindi nila alam yung nangyayari sa partnership, di ba? Okay. Interest cannot be assigned to make new partner, di ba? Hindi naman basta-basta. Sabi natin before, sa discussions natin, you need the consent of all the partners to make an assignee a partner. Interest is assignable with assignee acquiring all rights of the limited partner. Take note, precisely because what is contributed here is capital. Okay? What is the right of a limited partner? Ang mag-share lang sa profits, ang mag-share lang sa surplus, yun lang naman eh. So pag inassign nila yan, automatic pwede maging limited partner yung isa. Okay? His name may appear in the firm name. Of course, general partner, kapag nag-appear ang name mo sa firm name, you are liable up to your separate properties. Okay? How for limited partner naman, the name is not included in the firm name. Kapag kasali yan, okay, liable ka as general partner. Take note din, sabi natin kanina din, kailangan may word na limited sa name or LTD. Prohibited from engaging in a business-like partnership, di ba? Yung with regards to general partner na capitalist partner, kailangan hindi sila mag-engage into business that is of the same line as the partnership. While, if limited partner ka, walang prohibition. Okay? You can engage in any business. Why? Kasi hindi ka naman nag-manage ng business. Ang interest mo lang is sa shares. Shares sa profit, shares sa surplus. Okay? For a general partner, his retirement, insolvency, or death dissolves the partnership, of course. While for a limited partner, his retirement, insolvency, and death does not dissolve the partnership because there is no change in the relation, di ba? Pero kung general partner ang namatay, madi-dissolve yan. O malamang sa malamang, lalo na pag isa lang siya na general partner. Kasi hindi pwedeng panay limited partner. Okay? So those are the distinctions between a general partner or partnership and a limited partner or partnership. Okay? Sabi natin kanina, a limited partner can only contribute money or property. Okay? If in case he contributed industry, he becomes a general partner and therefore liable siya up to the extent of his personal property. With regards to time, dapat yung contribution ni limited partner, whether money yan or property, must be paid before. Take note, before the formation of the limited partnership. So, nagbabayad agad si limited partner. Why? Because basically that is your capital. Okay? Bago mag-operate yan, kailangan mo yung capital ni limited partner. Pero, pwede rin sila magdagdag ng additional contributions after formation. But, generally, ang contribution nila binibigay before formation of the limited partnership. As I've said earlier din kanina, the surname of a limited partner must not appear in the partnership firm name, of course, unless it is also the surname of a general partner, di ba? Okay lang yun, walang problema doon. Prior to the time when the limited partner became such, the business has been carried on under a name in which his surname appeared. Ibig sabihin, dating ganun na yung pangalan ng partnership, meron na yung apelido niya doon. Hindi pa siya partner, nandun na. Okay, doon lang, yung dalawang instance lang, pwedeng mag-appear ang surname ni limited partner. Okay? A limited partner whose surname appears in a partnership name contrary to the provisions of the first paragraph is liable, yung sabi ko, as a general partner to partnership creditors who extend credit to the partnership without actual knowledge that he is not a general partner. Okay? False statement in certificate. If the certificate contains a false statement, one who suffers loss by reliance on such statement may hold liable any party to the certificate who knew the statement to be false. So take note, the party who relied on the certificate that is false, okay, may hold any party to the certificate who knew the statement to be false at the time he signed the certificate. Of course, if you are aware of discrepancies or material false statements in the certificate, you should notify or amend immediately your certificate habang wala pang nagre-rely dun sa certificate na yun. Because once a third person or a third party, okay, suffers loss by virtue of relying on that certificate, pwede kayong lahat ng partner na nandun sa certificate pwedeng liable. Okay? Pero ipaprove kasi yan, dapat may knowledge at the time he signed the certificate. Okay? Subsequently, but within a sufficient time before the statement was relied upon to enable him to cancel or amend the certificate or to file a petition for its cancellation or amendment as provided in Article 1865. Or pwedeng, nakapirma na sila, nakapirma na kayong partners, tapos nalaman mo, saka mo lang nalaman nung nireview nyo yung certificate, na false, na merong mga material false statements dun sa certificate, na pwedeng mag-cause ng damage sa ibang tao, as third persons, dapat mapalitan nyo yun, makancel nyo or ma-amend nyo before merong ma-damage dun sa reliance dun sa certificate. Okay? So, knowledge of the false statement in the certificate could either be at the time he signed the certificate or subsequently. Okay? But within a sufficient time before the statement was relied upon. Ibig sabihin, meron kang reasonable time na i-amend or i-cancel yung certificate pero hindi mo nagawa. okay, you could be held liable. Okay? Limitations of a limited partner, na brief na natin to kanina. Limited partner has no control in the business. Of course, you cannot manage or share in the management of the partnership. Limited partner cannot perform acts of administration precisely because limited partner ka. Once he engages into acts of administration, he becomes liable as general partner to third persons. Ayun na pala yung consequences. A limited partner is liable as a general partner for the firm's obligations if it takes part or interfere in the management of the firm's business. So, pag limited partner, take note, hands off. Hands off sa business. Investor ka lang talaga. Capitalist. Investor ka lang. Let's go to the rights, powers, and liabilities of a general partner in a limited partnership. Tandaan, at least one general partner sa limited partnership. Therefore, meron siyang rights, powers, and liabilities. A general partner in a limited partnership is vested with the entire control of the firm's business and has all the rights and powers. Of course, siya ang nagmamanage ng business, as I have repeatedly said kanina, di ba? And is subject to all the liabilities and restrictions of a partner in a partnership without limited partners, i.e. in a general partnership. In short, liable siya to the extent of his personal property. It is in consideration of his, yun na sinasabi natin, unlimited personal liability for the obligation of the partnership that he is granted the general authority to manage the firm's business. Precisely, di ba? Liable ka hanggang separate property mo, hanggang private property mo. Malamang sa malamang, dapat ikaw din ang mag-manage niyan or may right ka na mag-manage diyan sa partnership. Bakit? Kasi pag nalugi yan or nagkaroon ng madaming utang, ikaw din naman ang hahabulin sa uli. So dapat ikaw din ang mag-manage para aware ka, di ba? Parang equal yung power mo dun sa liability mo. Okay, sabi nga nila, with great power comes great liability sa general partner. Great ang liability niya kasi unlimited personal liability. Great ang power niya kasi siya ang may control sa partnership business. Okay. As a rule, with regards to acts of administration or acts of strict dominion, he may bind, meaning the general partner may bind the partnership by any acts of administration. But he has no power to do the specific acts enumerated in Article 1850. This one we will discuss later. Okay, 1850. Even if agreed to by all the general partners. Kahit pa may consent lahat ng general partners. Sino dapat ang may consent? Written consent or at least ratification of all limited partners. With regards to 1850, general rule, pwede si general partner all acts of administration except 1850. Okay? Pero pwede niyang gawin yung 1850 if may written consent or at least ratification of all limited partners. The said acts are acts of strict dominion or ownership and are therefore beyond the scope of the authority of a general partner, meaning referring to 1850. Okay? What's 1850? Ito na yun, guys. Para hindi kayo masyadong mag-isip. 1850. Ano yung acts na hindi pwedeng gawin ni general partner? Do any act in contravention of the certificate. Of course, if it is stated in the certificate, parang agreement nyo na kasi yan, it must be followed. So, any contravention cannot be done. Okay? Do any act which would make it impossible to carry on the ordinary business of the partnership. Why? Because that is against the partnership's interests. Okay? precisely against din sa limited partner's interest. Confess a judgment against the partnership. Okay? Possess a partnership property or assign their rights in specific partnership property for other than a partnership purpose. Take note, gaya ng sabi ko kanina, numbers 2 to 4 are prejudicial to interest of limited partners. Diba? The general partner cannot admit a person as a general partner. Dapat may written consent or ratification. The general partner also cannot admit a person as limited partner unless he has the right to do so in the certificate, unless there is a written consent, or unless there is a ratification. Okay? Continue the business with partnership property on the death, retirement, insanity, civil interdiction, or insolvency of a general partner unless the right so to do is given in the is given in the certificate. Okay? This means kapag may namatay na general partner, dissolve ang limited partnership. Unless there is a right or stipulation there that the limited partnership shall continue kapag may namatay na general partner. But, hindi to pwede if ang namatay is yung sole, yung mag-iisang general partner. If dun sa limited partnership, isa lang ang general partner, pag namatay yan, talagang dissolve yan. Bakit? Di naman pwede mag-exist ang limited partner na limited partnership na panay limited partner. Diba? Dapat at least one general partner. Other limitations of general partners. The general partners, of course, have no power to bind the limited partners beyond the latter's investment. Of course, diba? They are only liable up to the extent of their share of the contributions. Neither do they have the power to act for the firm beyond the purpose and scope of the partnership. They have no authority to change the nature of the business without the consent of the limited partners. Take note. Rights in general of a limited partner. So tapos na tayo din sa rights ng general partner. Ngayon naman punta tayo sa rights ng limited partner. Okay? The limited partner, in order to protect his interest in the firm, has the same right to compel the partners to account as a general partner has. Therefore, in short, the limited partner, okay, has the right to accounting. Okay? Ano yung rights pa ni limited partner? Of course, to require that the partnership books be kept either sa principal place of business or kung saan naka-stipulate dun sa kanilang certificate of partnership. To inspect and copy at ito na yung right to inspect, ito na yung R. Ito na yung right to true and full information, the right to accounting, the right to ask for dissolution and winding up by decree of court. Can you mute your Miss Vinyas? Okay. May question ba? Wala naman. To receive a share of the profits or other compensation by way of income, of course. To receive the return, ito yung sinasabi natin kanina, to receive a share in the profits and in the surplus, to receive the return of his contribution. Pero yung up to the extent of his contribution only, provided the partnership assets are in excess of all its liabilities. Take note, itong difference niya dun sa general partnership. Sa general partnership, ang general partner, makukuha niya lang ang share niya kapag nasatisfy yung partnership creditors, di ba? Kailangan mabayaran mo na sila. Under limited partnership kasi, ang limited partner pwede niyang makuha yung contribution niya. Okay? Kahit hindi pa nabayaran yung partnership creditors. Paano, sir? Basta in excess yung assets over the liabilities. Okay? Pero kung mas madami na yung liabilities, hindi mo kuha ni limited partner yung share niya. Okay. Ito, yung article na maling akala. Bakit maling akala? Kasi a person who has contributed to the capital of a business conducted by a person or partnership erroneously believing, ito na yung maling akala, erroneously believing that he has become a limited partner. Akala niya limited partner siya or naging limited partner na siya sa isang limited partnership. Okay? Yung tao na yun is hindi, is not, by reason of his exercise of the rights of a limited partner, he is not a general partner with the person or the partnership carrying on the business or bound by the obligation of such person or partnership. Hindi siya general partner provided that on ascertaining the mistake, he promptly renounces his interest in the profits of the business or other compensation by way of income. Ito yung limited partner siya, but then sa certificate ang nakalagay general partner siya. Or limited partner siya, but then walang nakadesignate sa certificate kung limited partner siya or general partner. Ibig sabihin, blanco. Okay? Kapag gano'n lang nangyari, ang general rule dyan, kasi sabi niya dyan, without prejudice to the provisions of Article 1848, general rule dyan, liable ka as general partner. Pero, hindi ka magiging liable as general partner, okay? Once you ascertain the mistake, nasaan ba yung mali? Okay? And that you renounce. Okay? Anong sabi dyan? You renounce your interest in the profits of the business and other compensation by way of income. So, yun. Kapag merong mistake in regards to the certificate na limited partner siya, pero ang nakalagay doon general partner or hindi naka-identify, okay, anong kailangan niyang gawin para hindi siya maging liable as general partner? Okay, he must ascertain the mistake and renounce his interest in the profits of the business or other compensation by way of income. So, yun yung maling akala. Okay. What if, pwede ba sir na yung isang partner both general and limited? Pwede, di ba? Pwede. Okay? As long as it is provided, sabi dito, a person may be a general and a limited partner at the same time in the same partnership, provided that fact is stated in the certificate signed, sworn to, and recorded in the office of the SEC. Okay, so pwede na yung general partner is at the same time a limited partner. Okay, dalawa ang pagkatao. Either si Narda o si Darna. Di ba? Nakita niyo yung picture dyan. Dalawang pagkatao niya. Generally, his rights and powers are those of a general partner. So, he manages the partnership. Therefore, by virtue of such management, he is also liable to his separate properties. However, ito na, with respect to his contribution as a limited partner, he would have the right of a limited partner insofar as the other partners are concerned. What does that mean? This means that while he is not relieved from personal liability to third persons for partnership debts, he is entitled to recover from the general partners the amount he has paid to such third person. Meron siyang right of reimbursement from general partners. Yun yung maganda kapag dalawa ang katauhan mo. Okay? Kapag general partner ka, and at the same time, limited partner. Okay? And in settling accounts after dissolution, he shall have priority over general partners in the return of their respective contributions. Take note, as I have said earlier, limited partners are preferred over general partners in the return of their contributions. Ngayon, itong si dalawang pagkatao, si general and at the same time limited, okay? Nasa taas yung mga limited partner, nandito yung mga general partner, nasa gitna si dalawang katauhan, si general and limited. Ibig sabihin, may priority siya over other general partner. General partner siya pero mas mauna siya sa kanila by virtue of his being a limited partner. Yung right of reimbursement kanina, in case na maging liable sila sa separate properties nila, okay, at merong na benta na property ni general partner who is at the same time a limited partner, pwede niyang i-set off yun, i-recover sa other general partners. Yun yung kagandahan niya. Gaya ni Darna, di ba? Loan and other business transactions with limited partnership. So, under this, you have three. First, let's go to the allowable transaction. A limited partner, provided he is not a general partner, being merely a contributor to the partnership without the right to participate in its management, is not prohibited from what? Granting loans to the partnership. Therefore, the limited partner can be a creditor of the partnership, can transact other business with the partnership, can receive a pro rata share of the general partnership assets with general creditors if he is not also a general partner. Tandaan, sabi ko kanina, yung limited partner can receive his contributions kahit pa hindi masatisfy yung partnership creditors. Ang condition lang, basta mas madami yung partnership asset kaysa sa partnership liability. Okay? Para yung excess, dun mo kukunin yung share ni limited partner. I hope that is clear. Prohibited transactions. The limited partner in respect of any such claim is, however, prohibited from receiving or holding as collateral security any partnership property. Why? Because kapag hinold yan, di ba sabi natin kanina, pwedeng magpautang si limited partner. Tignan mo yung sa allowable transaction, yung una dun. The limited partner can grant loan to the partnership. But by granting this loan, that limited partner cannot receive or hold as collateral the partnership property. Hindi niya pwedeng ihawakan yun or kunin yung title dun sa property. Why? Because this could defraud creditors. This could defraud partnership creditors. What if naniningil na yung partnership creditors? Meron kang pautang sa partnership, ikaw na limited partner, may pautang ka sa limited partnership. Hawak mo yung collateral or yung security or yung partnership property. Okay? Ngayon, syempre ikaw, ayaw mo nang ibigay yun kasi gusto mo mabayaran ka muna. So, it will defraud partnership creditors. Receive any payment, conveyance, or release from liability if it will prejudice the right of third persons. Of course, paano ito mangyayari? If the partnership asset, okay, cannot satisfy partnership liabilities, pero naka-receive ka ng share mo, ikaw na limited partner, na-receive mo pa rin yung share mo, kahit pa ang dami niyong utang, hindi pwede yun. Kasi it defrauds creditors. Okay? Preferential rights of third persons. In transacting business with the partnership as a non-member, the limited partner is considered as a non-partner creditor. However, the third persons always enjoy, obviously, preferential rights insofar as partnership assets are concerned. Itong 3, i-relate mo dun sa second ng number 1. Transacting other business with it. Okay? Si limited partner, he can transact with the limited partnership. However, meron pa ring preference yung third persons over his interest in the partnership. Okay? So, dapat mauna lagi ang partnership creditors. Kung sa discussion natin before sa general partnership, dati partnership creditors, kung maalala nyo yung drawing natin, general partnership creditors muna bago yung partners, di ba? Dito naman kasi merong limited partners, may classification, partnership creditors, then limited partners, and then general partners. Ganun yung preference niya. Yun yung gusto nyo i-point out din nitong loans and other business transactions. The right of the limited partner to receive a share in the... Ito na yung sinasabi ko. Of the profits or compensation by way of income stipulated for in the certificate is subject to the condition that partnership assets will still be in excess of partnership liabilities after such payments. In other words, third-party creditors still have priority over limited partners, right? Diba? Partnership creditors, limited partner, general partner. Ibig sabihin, pwedeng makuha ni limited partner yung share niya kahit hindi pa nabayaran yung partnership creditors, provided that partnership assets will still be in excess of the partnership liabilities after such payment. Ibig sabihin, kung mas mataas na ang liabilities, hindi na pwede. Or, mas mataas ang assets, pero pag nabayaran, hindi na mabayaran yung liabilities, hindi rin pwede. So, yun lang yung regarding sa compensation ni limited partners. With regards to paragraph 2 in the slide, okay, this involves preference lang with regards to limited partners. Where there are several limited partners, kapag madami daw limited partner, the members or the limited partners may agree that one or more of the limited partners shall have a priority over the other limited partners as to the return of contributions. Ibig sabihin, yun sabi ko nga, kung 5 silang limited partner, kung sabi nila mauna si A, o di mauna si A sa kanila, di ba yung partnership creditor, limited partner, general partner. Kapag nasa limited partner ka na at merong preference sa ganyan, yan ang mag-a-apply. Okay, kung sino yung maunang mag-receive ng share. If such an agreement is made, it shall be stated in the certificate. So, dapat daw mayroon sa certificate. And in the absence of such certificate, of such statement, all limited partners shall stand upon equal footing. Ibig sabihin, they will receive their share sabay-sabay. Okay? Kapag hindi na ma-meet yung share nila, paghahatian nila kung ano yung natira. Walang matira sa general partner. As hard as it may sound, di ba? Okay. Requisites for return of contribution of limited partner. Ito na yung paulit-ulit din natin ni-discuss regarding return of contribution of limited partner. A limited partner shall not receive from a general partner or out of the partnership property any part of his contributions until, number 1, all liabilities of the partnership have been paid, if mabayaran na daw lahat ng utang. Or, yung sabi ko kanina, if they have not yet been paid. So, hindi kailangan na mabayaran mo na yung partnership liabilities. Okay? Or, if they have not yet been paid, the assets of the partnership are sufficient to pay such liabilities. Diba? Basta mas madami yung assets kaysa sa liabilities, pwede niyang makuha yung share niya. As long as after mabayaran, meron pa ring matirang assets. As in Article 1856, liabilities to limited partners on account of their contributions and to general partnership are not considered. Okay? Second, the limited partner shall not receive from a general partner or out of the partnership any property or any part of his contribution until merong consent yung all the members. Okay? Until all consent of all the members have been obtained except when the return may be rightfully demanded. So, general rule, pwede niyang ma-receive if may consent ng all members, pwede. Okay? Except when the return may be rightfully demanded. Anong ibig sabihin nito? Yun na yung na-explain ko kanina na kapag merong naka-indicate sa certificate na after 1 year makukuha niya na yung share niya, pwede niya lang i-demand. Pwede niyang exercise yung right niya, mag-demand siya na ma-return yung share niya. Of course, take note pa rin na kapag ginawa niya yan, dapat i-consider mo pa rin yung number 1, dapat meron pa ring assets sufficient to pay the existing partnership liabilities. Okay? So, it's all about remembering the core principles in limited partnership. Okay? Si limited partner, pwede niya makuha ang share niya. Anytime, sabihin mo na. Basta, yung asset is greater than liability. Or assets are able to pay the liability of the partnership kahit hindi pa mabayaran yung mga creditors. Okay? Or may consent yung members. Third, until the certificate is cancelled or so amended as to set forth the withdrawal or reduction of the contribution. Of course, if the certificate is cancelled. Okay? Or kapag kinancel kasi nga, mag-withdraw siya ng contribution niya. Or ibabawasan yung contribution niya. So, tandaan niyo yan, limited partner, general rule, shall not receive his contribution until mabayaran yung partnership liabilities. Or kung di pa mabayaran, basta may surplus yung asset sa liabilities. Okay? Or may consent yung members. Or mayroong time set to claim the contribution. Or upon cancellation of the certificate, amendment. Cancellation or amendment. When return of contribution is a matter of right, ito na yung kanina. Okay? Upon dissolution of the partnership. Of course, kapag dissolution na, winding up of partnership business, okay, return of contribution becomes a matter of right. Provided, mabayaran muna yung partnership creditors. Tandaan niyo yan, huwag niyo laging kakalimutan yan. Paulit-ulit. Second, upon arrival of the date specified in the certificate for return. Diba? If nakasabi dun sa certificate, after 1 year, pwede nang maklaim yung share nila in the partnership, pwede exercise as a matter of right. Doon na papasok yung sinasabi natin na except when the return may be rightfully demanded. Ito na yun. After expiration of 6 months, notice in writing given by him to the other partners if no time is fixed in the certificate for the return or dissolution. Meaning, the partner has given notice, okay, that he wants to withdraw. Okay, he wants to withdraw his share in the contribution provided mag-lapse muna yung 6 months. Okay? Take note, yung notice na yan, it must be in writing. So, after expiration of 6 months, notice in writing given by him to the other partners if no time is fixed in the certificate for the return or dissolution. In the absence of any statement in the certificate to the contrary or the consent of all members, a limited partner, irrespective of the nature of his contribution, has only the right to demand and receive cash in return for his contribution. Tandaan, meron tayong mga rights kanina, yung sinabi natin dun sa certificate, na kapag wala dun, wala din siyang right. Okay? Ang general lang na right niya is the right to demand and receive cash in return for his contribution. Take note, cash. Diba? Sabi natin kanina, if balikan nyo yung slide, kapag property, if merong naka-indicate certificate na meron siyang right na mag-receive ng property in lieu of the cash, pwede. Pero kung walang nakalagay sa certificate, in the absence of any statement, the certificate or consent, in cash lang. In cash lang. Take note ha, limited partner, in cash lang ang contribution nila na makuha. Okay. Additional grounds for the dissolution of the partnership upon petition of a limited partner. This is in addition to the grounds of dissolution we have discussed before dun sa previous topic natin under dissolution and winding up. So in addition to those, meron pang dalawa kung limited partnership. Okay? Ano yung isa? When his demand for the return of his contribution is denied, although he has a right to such return. Paano siya magkaka-right? Yung kakadiscuss natin. Ito, di ba? Kung merong specified date, okay? Kung meron na siya, kung nag-notice na siya ng 6 months at hindi binalik sa kanya yun, okay, he can now ask for dissolution. Why? Because hindi na binabalik yung share niya. Meron naman siyang right na singilin or meron na siyang right na i-exercise yung pagbalik ng contribution niya. Okay? The other liabilities of the partnership have not been paid or the partnership property is insufficient for their payment as required by the first paragraph, number 1, and the limited partners would otherwise be entitled to the return of his contribution. Okay? Basta take note, dapat mabayaran muna yung liabilities or sufficient yung partnership property. Pero kung sakaling ganun man, and he has the right, meron na siyang right to exercise to his contribution at meron pang utang si partnership or hindi enough yung assets ni partnership para sagutin yung utang tsaka yung return ng contribution niya, mag-ask na lang siya ng dissolution. Yun yung sinasabi nung number 2. Diba? If may right ka na, pero may utang pa si partnership or not enough yung asset ni partnership para mabayaran yung mga utang niya, okay, pwede ka na lang mag-ask for dissolution. Anyway, pag nag-ask ka naman for dissolution, lahat ng partnership assets naman is may exhaust in favor of the partnership creditors. Okay? The limited partners must first ask the other partners to have the partnership dissolved. If they refuse, then he can seek the dissolution of the partnership by judicial decree. Of course, ito kasi logical, parang natural. Why, sir? In number 1, when he demand the return of his contribution. Of course, when you demand the return of contribution, kanino masasabihin yan? Diba? Sa general partner, sa other partners, diba? So, yun na yung una nung dun sa last paragraph. Diba? If dinay ka nila nun, okay, go for judicial dissolution. Ganun din naman sa pangalawa, diba? If you want to exercise your right to claim your contribution and meron pa ring utang or not enough yung asset, okay? Siyempre, ang una mong sasabihin yan, yung mga partners, di ba, na may intention ka, na kunin na yung share mo. Of course, after failure dyan, you can ask for judicial dissolution. Okay? Kaya lang sinabi yan ng law, ng batas, because mas prefer ng court na masettle ang issues actually outside court. Kahit saan naman. Kahit civil case, kahit anong case kasi yan, guys. Preference ng court, maayos yan outside the court. Wala nang aabot pa sa kaso. Okay? Kaya yan nilagay sa batas. Liabilities of a limited partnership. To the partnership, of course, they have limited liability. Gaya na sabi natin kanina. They are not principals in the transaction of their partnership. The liability is to the partnership and not to the creditors of the partnership. Meaning, ang liability lang nila is to the partnership. Ano yung liability nila sa partnership? Yung contribution. Once nabigay na yung contribution ni limited partner, wala na siyang liability. Okay? As long as hindi siya mag-manage, kasi ang sabi natin, pag nag-manage siya, liable siya as general. Okay? Basta nabigay niya na yung contribution niya sa partnership, okay na. Tapos na. Okay? To partnership creditors and other partners, of course, this is when a limited partner is liable as a general partner. Ito, yung sabi ko, paulit-ulit, is liable for partnership obligations when he contributes services instead only of money or property to the partnership. Diba? If he contributed industry, liable as general partner. If he manages the business, liable as general partner. When he allows his surname to appear, diba? Na-discuss natin, liable as general partner. When he fails to have a false statement in the certificate corrected knowing it to be false, diba? Yung sabi natin, false statement in the certificate, kung sino ang nasa certificate, liable dun sa third person. Therefore, liable sila as general partner. When he takes part in the control of the business, nasabi na. When he receives partnership property as collateral, ito yung prohibited transaction. Di ba guys? Maalala nyo kanina, pwedeng magpautang si limited partner kay limited partnership. But, si limited partner, hindi siya pwedeng humingi ng collateral security. Ano yan? Lupa, building, hindi siya pwedeng humingi ng property ni limited partnership. When there is failure to substantially comply with the legal requirements governing the formation of limited partnerships, ano yon? Yung sign and swear in the certificate and register with the SEC. How about to separate creditors? Separate creditors, ibig sabihin yung utang ni limited partner. As in a general partnership, the creditor of a limited partner may, in addition to other remedies allowed under existing laws, apply to the court for a charging order. Of course, alam nyo na yan guys. Na-explain ko na yan, may example na rin tayo dyan. Subjecting the interest in the partnership of the debtor partner for the payment of his obligation. But take note, under charging order, tandaan nyo lagi, basta walang ma-defraud na partnership creditor. Ibig sabihin, pag may utang pa, si limited partnership sa creditor niya, hindi pwede yung charging order, di ba? As I have discussed previously. Okay? Rules on assignment of limited partners' interest. Although na-touch natin to konti kanina, di ba? A limited partner may assign his interest, of course, just like what I have discussed before. A partner may assign his interest in the partnership to another person. However, the assignee is only entitled to receive the share of the profits or other compensation by way of income or the return of the contribution to which the assigner would otherwise be entitled. In other words, what the assignee would get as a right is what the assigner has as a right. Kung ano lang yung right, in other words again, kung ano lang yung right ni limited partner, yun lang yung magpapas kay assignee. His rights are similar to those of person to whom a partner conveyed his full interest in the partnership. An assignee shall have the right to become a substituted limited partner if the assignee can become a limited partner or if he can substitute the limited partner, merong conditions. All the members, number one, all the members must consent, of course. Pero hindi siya gaya nung general partnership. Why? Because of number 2, the certificate must be amended. Tandaan. Kung yung sa general partnership, yung assignee, bago maging partner, kailangan ng consent of all partners, of all general partners. Sa limited partnership, yung assignee, bago maging limited partner, dapat may consent, same dun sa general, okay? But, dapat ma-amend yung certificate. And yung na-amend na certificate, ma-register ulit sa SEC. Ganun yung peculiarities ng limited partnership. Why? Because the nature, precisely, it all boils down to the nature of the limited partnership, di ba? Bakit? Kasi yung limited partnership, limited liability, kailangan mong i-put into notice yung third persons. Kaya every time na may changes dyan, guys, lagi nyong isipin, every time na may changes sa limited partnership, kailangan may amendment certificate. Kung may bagong limited partner, consent, amend certificate, pasa ulit sa SEC. Okay? Ganun siya. Unlike sa general partnership. Substituted limited partner is a person admitted to all the rights of a limited partner who has died or has assigned his interest in a partnership. So, yung assignee. The substituted limited partner has all the rights and powers and is subject to all the restrictions and liabilities of his assignors, except those liabilities of which he was ignorant at the time he became a limited partner and which could not be ascertained from the certificate. Kaya kailangan merong amendment lagi ng certificate. Tandaan na kapag yung assignee naging substituted limited partner. Okay? Yan ang rights na makukuha niya. Pero liable lang siya dun sa liabilities na alam niya, na he became aware of. Okay? Because if there are liabilities of which he was ignorant, hindi siya pwede maging liable dun. Yung share niya, and which could not be ascertained from the certificate. The substitution of the assignee as a limited partner does not release the assigner from liability to the partnership under Article 1847 in the case of false statement in the certificate, and when the limited partner takes control or takes active control in the management. So, kung ang ibig sabihin niyan, guys, if si limited partner, okay, siya yung nag-take control of the business for a short period of time, and then after niyan, binenta niya yung interest niya into another person, to an assignee, and that assignee eventually became a substituted limited partner, hindi ma-absuelto si former na limited partner. Why? Because naging liable siya from the time na nag-take part siya or na nag-share siya sa management ng limited partnership. So, yun yung assignment of interest by a limited partner. Pwede niyang i-assign. Okay? Yung in-assign niya, maging assignee, yung rights niya is to the share, the profits and the surplus. Okay? Yun lang yun. Pero pwede din, yung assignee pwede maging limited partner provided all must consent, amendment in the certificate, and recorded in the SEC. Okay? 1860. The retirement or withdrawal, debt, insolvency, insanity, or civil interdiction of a general partner dissolves the partnership. Okay? General partner, any general partner na namatay, naging insolvent, nag-withdraw, will dissolve the limited partnership. While any of such causes affecting a limited partner does not result in dissolution. Unless, of course, isa na lang si limited partner. Okay. Kapag namatay, nabaliw, or na-convict ng heinous crime si general partner, dissolve ang limited partnership. Pero kapag si limited partner naman ang nangyari lahat ng yun, okay, hindi madidissolve ang limited partnership unless mag-isa lang si limited partner. Pag mag-isa lang si limited partner, dissolve ang limited partnership. Okay, now let's go to dissolution of a limited partnership. A limited partnership is dissolved in much the same way as an ordinary partnership. So, yung causes na na-discuss natin noon, so kasama yun, pwede siyang ma-dissolve by virtue of that. Pwede din yung na-discuss natin kanina, yung a limited partner may ask for dissolution kung hindi na ibigay yung share niya, kung may right siya na humingi nun, di ba? Okay? And these instances. Misconduct of a general partner. Of course, general partner siya, meaning, lalo na pag mag-isa lang siya, siya ang nagmamanage ng business. You cannot afford misconduct of a general partner. Kasi sa kanya nakasalalay yung performance ng limited partnership. Kapag nagloko siya, okay, affected ang interest ni limited partner. Fraud practice on the limited partner by the general partner. Of course, since si general partner ang nagmamanage ng business, if meron siya mga fraudulent transactions, especially with regards to the share of the limited partner, pwedeng mag-ask for dissolution or pwedeng ma-dissolve ang partnership. Retirement debt of a general partner, yun sabi natin kanina. When all the limited partners cease to be such, meaning, kapag lahat ng limited partners either nag-withdraw or kung isa na lang siya, namatay, nag-retire, okay, yun. On the expiration of term, of course, pag nag-expire ang term ng limited partnership, dissolve. Okay? Kapag in-extend mo yan, maging general partnership yan. Yun, di ba? Na-explain ko yan kanina. Okay? Kung gusto mong i-extend yan, kailangan mo ng amendment din ng certificate. Why? Kasi sa certificate, doon mo makikita yung term. Okay? By mutual consent of the partners before the expiration of the firm's original term. Okay? By mutual consent. After that consent, papalitan nyo, of course, yung certificate. Okay? Notice of dissolution. When the firm is dissolved by the expiration of the term fixed in the certificate, notice of this dissolution need not be given. Why? Because mayroon ng notice dun, di ba sabi ko kanina, yung certificate kasi nila yan, it serve as a notice to the third persons or to the public na yung partnership nyo is limited in all its peculiarities. So kung nakalagay dyan, certificate na 10 years yan, hindi mo na kailangan ng notice of dissolution. It need not be given since the papers, yung paper na yan, yung certificate, is filed and recorded in the SEC, are notice to all the world of the term of the partnership. Okay? Parang batas yan, guys. If i-relate ko lang din, if maalala nyo, if narinig nyo na yung term na ignorance of the law does not excuse anyone. Diba? Ignorancia legis. Hindi ko na alam. Basta yun. Ignorance of the law does not excuse anyone from compliance therewith. Okay? Big sabihin, kahit ikaw na ordinaryong tao, hindi mo alam na may naipasang ganun na batas. Okay? Kapag may ginawa ka na against sa batas na yun, liable ka. Hindi mo pwedeng sabihin na hindi ko alam. Okay? Wala akong alam. Hindi ko alam na may batas na ganyan. Hindi pwede. Why? Parang ganyan yung mag-a-apply dito. Because nung pinasayang batas na yan, pinablish yan sa dyaryo. Okay? Kahit pa nakita mo yung dyaryo na yun o hindi, or binasa mo o hindi, yun na yung notice sa inyo. Ganun yun, guys. Kaya, ignorance of the law doesn't excuse anyone from compliance therewith. Okay? Ganun din siya dyan. Kapag pinasa na yung certificate sa SEC, that is notice to the public, that is notice to the world na ito ang peculiarities ng limited partnership namin. Okay? Ganito yung term niya, ganun. Hindi mo na kailangan notice. But, if dissolution is by the express will of the partners, the certificate shall be cancelled, and a dissolution of the partnership is not effected until there has been compliance with the requirements in this effect. So, we are going to discuss later about cancellation of the certificate. Okay? So, natapos na yung dissolution, winding up na tayo. The consequences of the dissolution of a general partnership apply to a limited partnership. So, parehas yung consequence. Therefore, kapag na-dissolve, hindi na kayo pwede mag-transact ng new business. Okay? Pwede lang mag-continue yung operation with regards to winding up. Pag sinabing winding up, settlement of existing obligations, di ba? Settlement of accounts. Or collection of your remaining accounts receivables if meron pa kayong di na-kolekta. Ganun lang. Wala nang bagong transactions. Okay? Ay, bumalik. Priority in the distribution. Bakit may ganyan? In the distribution of partnership assets. Kasi pinag-distribute nila yung nakuha nila. Okay. Priority in the distribution of partnership assets. Ito na yung gist ng mga sinabi ko kanina. Okay? The partnership liabilities shall be settled in the following order. These are the preference. Those due to the creditors, the partnership creditors, including limited partners except those on account of their contributions. Di ba ang sabi natin kanina, si limited partner pwede siyang magpautang kay partnership, hindi lang siya pwedeng humingi ng collateral, di ba? Pwede yun. So, silang mauna. Okay? Those due to limited partners in respect to their share. So, yung kanina, partnership creditors, and then limited partners as creditors, and then limited partners with respect to their share in the profits of the business. Yung third, limited partners for the return of the capital contribution. Okay? Kung meron pang taking note of the fact if meron pang partnership assets na matira. After mo masatisfy yung limited partners with regards to their share and contribution, dun ka na pupunta sa general partners. General partners other than for capital and profits. General partners in respect to profits. Itong general partners other than for capital and profits. Yan na yung dito ata pumapasok yung general and limited partner, yung in between, yung dalawang katauhan. Okay? Those due to general partners for the return, of course. So in summary, partnership creditors, limited partners, and general partners. Partnership creditors are entitled to first distribution, of course, followed by limited partners. Ay, yun na pala yung discuss ko. In a general partnership, the claims of the general partners in respect of capital enjoy preference over those in respect of profits. Okay? Yun na pala yung discuss ko. Okay, how about this one? Time. Okay. 7:30. So, i-upload ko na lang siguro ito later yung part 2 para ma-finish because it's already 7:30. Konti na lang naman siya, konting slides. So we pick up from where we left off. This is an example of when a limited partner received the return of his share even before the creditors are paid. So here we have limited partnership ABC. A lawfully received the return of his contribution of 10,000 on the date specified in the certificate. So, na-receive niya yung share niya on the date specified in the certificate. But subsequently, limited partnership ABC became liable to X. Is A liable? Okay, tandaan nyo, na-receive nyo yung share before nag-arise yung liability. Therefore, A is no longer liable to X. Okay? But what if? What if A is no longer liable? What if insufficient yung partnership assets na? Paano yun? Okay? Ang habulin po dyan is yung general partners. Okay? Or general partner if isa lang. What if the liability arose before A received this contribution? Okay, dito iba na ang sagot mo. If A received this contribution, if the liability arose before A received this contribution, okay, A is liable. Okay? If 10,000 if 7,000 yung utang, liable siya up to 7,000. Okay? If 15,000 naman yung utang, liable siya hanggang 10,000 lang. Why? Because he is a limited partner and he is only liable up to the extent of his share of contribution. So, yun yung answers dyan. When certificate shall be cancelled or amended. Okay, there are two instances where a certificate should be cancelled. Okay, when the partnership is dissolved other than by reason of the expiration of the term. Of course, sabi ko nga kanina or previously, kapag ang partnership na dissolved by virtue of the expiration, you don't need to cancel the certificate. Why? Because nag-expire na yung term, di ba? You don't need notice, di ba? Wala na rin notice of dissolution. Okay? Saka lang siya maka-cancel kapag other reasons. Pero kung expiration, no need to cancel. When all the limited partners cease to be such. Okay? A limited partner cannot exist as such if there are no more limited partners. Of course, if naubos na yung limited partners, dissolve na yan. Okay? Cancelled dapat ang certificate. Dapat makancel ang certificate. Okay? With regards to amendment, okay, there is a need to amend the certificate for the following. So, kapag nangyari itong mga bagay na to, kailangan ma-amend yung certificate. Ito na-encounter natin kanina. There's a change in the name of the partnership. Kailangan amend. In the amount or character of contribution of any limited partner, kailangan ng amendment. Why? Because the contribution, the name of the partnership is all in the certificate. Kung may magbabago dyan, kailangan mabago din yung certificate. Okay? When the person is substituted as a limited partner, di ba, in-explain natin kanina, yung assignee naging limited partner, di ba, kailangan ng consent, kailangan ng amendment, and ipasulit sa SEC. When an additional partner is limited partner is admitted, kailangan ng amendment. When a partner is admitted as a general partner, kailangan ng amendment. Kasi lahat itong mga bagay na to nasa certificate. When a general partner dies, retires, or become insolvent or insane, okay, kailangan, and the business is continued, kailangan ng amendment. There is change in the character, amendment. There is false, of course, there is false or erroneous statement, kailangan mong i-amend yung certificate. If not, di ba, you will be liable. Lahat ng nasa certificate, liable. There's a change in the time as stated in the certificate for the dissolution of the partnership. If nag-iba yung term nyo, di ba, amend the certificate. A time is fixed for the dissolution or the return of a contribution, no time having been specified in the certificate, or the members desire to make a change in any other statement in the certificate in order that it shall accurately represent the agreement among them. What are the requirements for amendment and cancellation? Okay? For amendment, it must be in writing. Okay? It must be signed and sworn to by all the members, including yung mga bagong i-admit. Okay? And the certificate must be filed with the SEC. So, kapag amendment, it must be in writing, must be signed and sworn to, and filed in the SEC. For cancellation, it must be in writing, signed by all the members, filed with the SEC. If the cancellation is ordered by the court, certified copy of such order shall be filed with the SEC. Ito yung mga judicial na cancellation. Okay? So, tandaan kung amendment, dapat in writing, signed and sworn to by all the partners, kahit yung mga bago, and filed with the SEC. Kapag cancellation, okay, must be in writing, signed by all the members, filed with the SEC, and kung cancellation is ordered by the court, certified true copy of that order. The approval by the commission of the amendment or cancellation is no longer required. So, that ends our topic on limited partnership.